Hello everybody, welcome back to the channel, the Butterfly Monkey channel. Today's topic will be elementary law. Elementary law consists of many topics dealing with private rights, public rights, equity, proceedings in equity, you name it, it is here. This is a 473-page book. I will not be reading this whole book, but instead be reading specific chapters. All right. The first chapter that I will be reading from is the citizenship chapter. All right. I have 6 books, PDFs, that I will be reading from specific to the citizenship chapter. There's only one of them that's a really long chapter. Not really long, but 6 pages or something like that. The dates, the copyrights of each of these PDFs vary by about 30 years maybe. The oldest one I have is 1882, which is the Robinson one, the one that I shared in my Telegram group. And the last one is from 1915 by a guy named Fishbeck. All right. So today I will start with citizenship. And this will be section 361. All right. So chapter 2 of subjects and their relations to the state. So if anyone is hurt or feelings are hurt by the word subjects, this is not a video for you because you do not understand context. Okay. So section 360, a subject is a person who is under legal obligation to submit to the authority of a state in matters relating to the public welfare. That's what that means, not in your private capacity. The extent of this obligation depends upon the political character of the subject and the duties he may owe to other states. And they give you additional readings. This is Black's Law Commentaries, and I don't know what these guys are here. This is Jamison Constitution, but this I never heard of. I looked this up in the law library. I cannot find it. And this is Jamison Constitution book. Section 361 of allegiance. The tie which binds the subject to the state is called allegiance. It originates in the compact which is presumed to have been made between the subject and the state at the commencement of their political relations with each other, and is at once the foundation and the measure of the rights which the state has in its subjects, and which they in their turn possess in or against the state. Allegiance is of 2 kinds, natural and local. Natural allegiance is universal and perpetual. It cannot be forfeited, canceled, or released by any change of time or place or circumstance. Only his own death or the act of the state can discharge the subject from its obligations. Local allegiance is territorial and temporary. It binds the subject while actually within the state, but may at any time be terminated by his removal from it. And again, they give you Black's Law Commentaries, Kent Commentaries, and Wolseley International Law. Highly recommend getting some of these books. I do have Black's Law and Kent's. I do not have Wool's. Section 362 of native-born citizens. Subjects are of 2 kinds, citizens and aliens. A citizen is one who owes the state of which he is a citizen and universal and perpetual allegiance. Citizens of the United States are of 2 classes, native-born and naturalized. A native-born citizen is one who was born within the jurisdiction and allegiance of the United States. The jurisdiction of the United States is coextensive with its territory and embraces all persons resident therein, except Indians and the official representatives of foreign states, foreign countries. The allegiance of the United States includes all its citizens, whether at home or abroad, and all other persons except Indians and the official representatives of foreign states who are permanently domiciled within its jurisdiction. The persons born within the jurisdiction and allegiance are the following: those born either at home or abroad of parents who are citizens. Number two, those born within the territory of the United States of alien parents, Indians and officials, representatives of foreign states excepted, who are permanently domiciled within the United States. And again, they give you additional reading here. They give you Pomeroy municipal law and Cooley's constitutional law, in addition to the others. I never read Vattel. I can't find it. Section 63, 363. A naturalized citizen is one who was originally a citizen of a foreign state, but by the act of the United States has been adopted by its citizen. The right of a citizen thus to determine his allegiance to the state in which he was born and assume the obligations of natural allegiance towards another state has always been controverted, and even in the United States seems opposed to the current of judicial opinion. The right, however, has been practically exercised for many years and has been expressly affirmed by acts of Congress. It has been recently obtained a legal sanction by means of treaties between the United States and certain foreign powers. Section 364 of naturalization. The subject of naturalization is regulated by the statutes of the United States. Those statutes recognize 4 classes of persons as entitled to become adopted citizens: persons who have resided in the United States since 1812. Number 2, persons over 21 years of age who have resided in the United States for a period of 5 years and legally declared their intention, meaning changing their domicile, to become citizens of the United States more than 2 years before their naturalization. Number 3, persons over 21 years of age who have resided in the United States for a continuous period of 5 years, 3 of which were during their minority. Number 4, persons over 21 years of age who have resided in the United States for 1 year and who have served in the military forces of the United States and have been honorably discharged therefrom. Any such persons appearing before the court of record, proving their compliance with these conditions and taking the requisite oaths of allegiance, are admitted together with such of their minor children as are resident in the United States to all the privileges and responsibilities of citizenship. And again, they give you more to read. I'm not going to read of aliens. Section 366 of citizens of the individual states. All citizens of the United States are citizens of the individual state in which they were born or naturalized. 2 things here. Or in which they may have become permanently domiciled. They are entitled to enjoy during their residence in or transit through any other state all the immunities and privileges which belong to its own citizens. This should be a given, and most things that we should have a familiar understanding with. All right? This one was short and sweet, but not really in detail. The other books are better detailed. So this book right here is same thing, A Manual on Elementary Law by a guy named Smith. Denton Smith, I think his name is. So citizenship and naturalization. They give you bullet points here. No one can be a citizen of a state unless he is a citizen of the United States. This right here, I don't really understand the writer's interpretation of this, because I have for sure have read court cases where the citizenship of the United States is based on the condition of being a citizen of a state first. So how he's interpreting this, I do not know. Bullet point number 2, citizenship of the United States renders a person a citizen of the state in which he resides. Citizenship of the United States may be A, by nature, that is, where one is born within the territorial limits of the United States and subject to the jurisdiction thereof, that's the 14th Amendment, and B, by naturalization, that is, where a foreigner renounces his allegiance to his sovereign and becomes a citizen of the United States in accordance with its laws. Now, this is, of course, naturalization. So he just stated here the 14th Amendment. Under the Articles of Confederation, there was no such thing as citizenship of the United States. Citizenship of was a state matter exclusively. In the Constitution, however, citizenship of the United States is repeatedly referred to. That means what? They have used the word citizenship of the United States or U.S. citizenship multiple times before the 14th Amendment. Understand this if you have not read the Constitution ever in your life. And in the 14th Amendment, state citizenship is also mentioned. No person can be a citizen of any state unless he is also a citizen of the United States. And they give you Cooley's Constitutional Law, page 244. No person can be a citizen of any state unless he is also a citizen of the United States. If, however, he is a citizen of the United States, he becomes, by virtue of his citizenship, a citizen of the state in which he resides. Citizenship in the United States may be by nature or by naturalization. Citizenship by nature is the result of birth within the territorial limits of the United States and subject to the jurisdiction thereof. The process of naturalization is available to any free white persons and to persons of African nativity or descent. Remember, the second book is 1894, I think, or 1896. So remember, these books are older, so they're going to have some type of racial comments like this. Naturalization is covered by the following rules. 1, the applicant must declare an oath 2 years prior to his admission, and it is his bona fide intention to become a citizen of the United States and that he renounces all allegiance to foreign powers. At the time of his admission, he must have for 5 years a resident within the United States and at least 1 year in the state or territory where he's admitted. 3, he must renounce any title of nobility which he possesses. Number 4, he must declare an oath that will support the Constitution of the United States. And number 5, the country from which such alien comes must not, at the time he seeks to be naturalized, be at war with the United States. 6, the applicant must be a person of good moral character. 7, minor children of naturalized citizens are citizens of the United States if they reside within the United States at the time of the naturalization of their parents. So this, as you can see, differs from the naturalization principles that the first book gave. One thing that you have to understand, this right here for naturalization and the requirements for it can and will always probably change in some respect or another. Why? Because Congress has supreme authority over this, and it's made by statute, and they have full power to change it whenever they want. This is going to give you a subsect annotation. By special treaties, members of certain Indian tribes have been accorded the privilege of becoming citizens. Such a treaty was entered into with the, I'm going to chop this up, Choctaws in 1830, and with the Cherokees in 1836. Now, this right here, a court case for this to read will be Elk versus Wilkins. I can't remember the rest of the citation, but that is a case where an Indian born on his reservation, which is federal territory and not part of the state, So that means that the 14th Amendment does not apply to him, right? He wanted to leave his governing body, the political bonds he has with the Indian tribe of his village, and domicile into the state of whatever state that he's in. By doing so, he has to use the laws of naturalization because the 14th Amendment does not apply to him. All right? Hopefully you guys understand that. The third book. This is by Fishbeck. This is a manual on elementary law. Let me see what's above it, if I need to read above first. International law and citizenship. I'm not going to read that. I'll let you guys decide if you guys want to read that. Meaning that you guys, if you guys want the book, just let me know in Telegram. So section 20. Citizenship is the state of being vested with the rights and privileges of the citizen. This book, I think, is 1896. So I have two of them from 1896 by two different authors. In this country, there are two kinds of citizenship and allegiance, one national and the other state. It is for Congress to determine who shall enjoy the privileges of national citizenship within the limits prescribed by the Constitution, and the laws of the several states fix the conditions under which state citizenship is acquired. Now, what did they just say? U.S. citizenship is of national character. Who gets to make the laws and the rights and privileges for that national character? Congress does, not God. No state can make or enforce a law which shall abridge the privileges and immunities of citizens of the United States, nor can any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of its laws. This is a provision of the Constitution of the United States, and any state law to the contrary is void. It is further provided in the Constitution that the citizens of each state shall be entitled to all the privileges and immunities of citizens in the several states. The right of a citizen to expatriate himself and become a subject of another nation was questioned in this country until Congress passed a law recognizing such right. Section 21. Citizenship is acquired by birth or by naturalization. Congress has sole power to establish uniform rules of naturalization. It is in the power of the states to adopt citizens on easier terms than the laws of Congress may impose, but they have no power to exclude from citizenship those who have been naturalized according to the laws of Congress. By these laws, the applicant must make oath before the proper officer at least 2 years before his admission that it is his intention to become a citizen and renounce his allegiance to his own sovereign. At his final admission to citizenship, he shall make oath and that he will support the Constitution of the United States and renounce all allegiance to any foreign power, especially his own sovereign. He must prove by at least 2 citizens, right, his 2 witnesses, that he has resided in the United States 5 years within the state or territory where he is located. 1 year, at least 1 year. So here he is. What proof do you need? Testimonial by witnesses, not some documents of, how do they do it today? With state IDs and passports, they want you to give them some commercial contract, some receipt of some bill, from electric bill to gas bill or whatever else. Right? It has never been just that. It's always been witnesses, as the primary aspect. That he has been a moral person and is attached to and well disposed toward the principles of his government. He must also renounce all titles to nobility, if he have any. A minor alien, not a Chinese at this time, of course, who shall have resided within the United States 3 years next preceding his majority, and so residing at the time of making his application, may, after reaching his majority, and having residing in the United States 5 years, including the 3 years during his minority, be given citizenship without preliminary declaration. An alien who is over 21 years of age, who has enlisted and served in the armies of the United States as a regular or volunteer, and has been honorably discharged if he has resided in the United States 1 year, be admitted to citizenship without preliminary declaration. Children of naturalized parents who were under age when the parents were naturalized shall, if residing in the United States, be considered citizens. By the laws of some states, aliens who have declared their intention to become citizens of the United States and have resided in the United States 1 year are allowed to vote in the state where they reside. And I'm not going to read aliens. So the next book is a Handbook of American Constitutional Law. Right, this is going to be chapter 19, Political and Public Rights. This is the one that's more thorough, I guess, the better word to say. Right? So section 224, more detailed for sure. The 14th Amendment to the Federal Constitution declares that all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. With respect to the manner of acquiring citizenship, the citizens of the United States are divided into two classes, native-born citizens and naturalized citizens. And native-born citizens does not mean being born on federal territory. The term United States here does not mean federal territory. It means the Union States. Citizenship in the United States is not restricted to adults or males, but belongs equally to women and children. These are subnotes. These are bullet points. Corporations cannot be citizens of the United States, which is a given. And under the state citizenship, right, they don't have the same. They're not citizens and afforded the privileges and immunities as state citizens either. The native Indians, though born within the United States, can become citizens only by naturalization. The right of expatriation is fully recognized in this country. I forgot what year this book is. I think it's 1904. I'm not sure. It's not right here without me scrolling all the way up. But I know it's the first three books are the only ones prior to 1900. The next three books are after 1900. I think 1901, 1904, no, 1910. I had these, 1910, 1911, and 1915. All right, so this is the 1910 book. Before the adoption of the 14th Amendment, the rights and status of a citizen of the United States were very doubtful. It was even uncertain whether there was anything under the federal system corresponding to citizenship in the several states. Many publicists contended that if there was a citizenship of the United States, it was possessed by virtue of and resulting from citizenship in a state, and that's of course the court case that I read. If I can't recall which one specifically, it's not the slaughterhouse cases. It's not Kim versus the Chinese one, Kim Walk or whatever. Kim, I can't pronounce it. This, of course, excluded the definition of citizenship. All the residents of the United States who were not citizens of some other state, right? So in the context that how that's speaking, right? If you're a citizen of one state, well, you're not a citizen of the other state. So that inherently excludes everyone else, right? Including the inhabitants of the territories and of the District of Columbia, Indians and Negroes at this time. These persons, it was thought by some, were not citizens at all. In the Dred Scott case, Chief Justice Taney stated that the question at issue was as follows: can a Negro whose ancestors were imported into this country and sold as slaves become a member of the political community formed and brought into existence by the Constitution of the United States, and as such become entitled to all the rights and privileges and immunities guaranteed by that instrument to the citizen? One of which rights is the privilege of suing in the court of the United States in the cases specified in the Constitution. And this question was answered in the negative, so they denied it. But if you understand when this case was deliberated, right, the Constitution did not apply to everyone. It only applied to white persons. The principles that encompasses all people, regardless of color and creed, right, were not fully established until, of course, the 14th Amendment and so forth. But there are court cases that show otherwise, just so you guys understand that. It wasn't fully recognized until the 14th Amendment, but there are plenty of court cases that show that it was recognized by the courts. Not in all cases, but in some cases. It did not apply to the Chinese, and it did not apply to Negroes, though. The black race, the enslaved race at the time, which weren't the only slaves either, so that's a misnomer also. The purpose of the 14th Amendment was to secure to the newly emancipated colored race the rights and privileges which belonged to them since the abolition of slavery by the 13th Amendment, in common with all others living under the protection of federal law. It conferred upon them citizenship in the United States with all its privileges. It did not make them citizens of the states. Remember this. The act itself did not make them citizens of the state. Something else had to be included in that for them to become citizens of a state. But it gave them the right to acquire citizenship in a state, in addition to their federal citizenship, by residence therein. Though necessarily general in its terms, this amendment applies especially and peculiarly to these people. There have been very few cases in which its benefits have been invoked by any others. It is held that no white person born within the limits of the United States and subject to their jurisdiction, or born without those limits and subsequently naturalized, owes its status of citizenship to the amendment. But that's, of course, back then. Reading, and they give you annotation, Van versus Valkenburg versus Brown, right? Which I have not read. It's an 1872 case, which I will be reading after I'm done reading this. The promotion of colored persons to citizenship by this provision is an admission to all the rights and privileges of white citizens in the same manner and to the same extent. They cannot be distinguished from other citizens by legislation for any of the causes which previously characterized for their want of citizenship. Now, what are they speaking of here? Their want of citizenship. Those are based on race, religion, creed, and whatever else, right? But it's specific. It's not general. They are characterizations that are enumerated. Let's see what they give you an example here. Number 3. They give you a case, Burns versus State. That is I forgot what that case is. Definition of citizenship. Citizenship is a status or character of being a citizen, and a citizen of a given state or country is one who owes its allegiance and is entitled to its protection. Oh, I didn't read this part. But at the same time, it must be remembered that the 14th Amendment does not add to the privileges or immunities of citizens, but only furnishes additional protection for the privileges already existing. So they're talking about the first privileges and immunities, meaning the privileges and immunities of a state citizen. And I already read that. Citizenship is the status or character of being a citizen, and a citizen of a given state or country is one who owes its allegiance and is entitled to its protection. The two correlative ideas of allegiance and protection form the basis of the legal and political conception of citizenship. The citizen is subject to the jurisdiction of his country and to its laws. It owes its loyalty, his services at need, and his money to defray its expenses. That's just taxes to pay off the debts of the government, of the federal government. In return, he is entitled to claim its protection against domestic violence and foreign oppression. The possession of civic rights is not the test of citizenship. There are many who are legally incapable of voting for public officers, or of filling the offices themselves, who are nonetheless citizens. And of course, this is American nationals. For those who believe they are American nationals, that term expressly does not apply to any person born within the state of a union, because those persons are not eligible. American nationals cannot vote. They have other privileges, but because they are not of a state, right? They are of a territory. They don't have those. They are not afforded those privileges. Neither is the mere inhabitancy of a country a test of citizenship. For resident aliens owe a local and temporary allegiance to the state wherein they live and are amenable to its ordinary laws. But where the two characteristics of allegiance and protection are found in their completeness, and together their citizenship exists. So if you have both, two characteristics of allegiance and protection are found, right, then citizenship exists. The question is, does that apply to you, right? Is there an allegiance from you and protection? How do you acquire allegiance? Native-born citizens. The 14th Amendment divides citizens of the United States into two classes. That means both classes are what? Citizens of the United States. This is for those who believe they are not citizens of the United States. You might not be a citizen of the United States pertaining to a specific context, right? Like federal taxation or something, right? But in general, you absolutely are. First, those who are born in the United States and subject to the jurisdiction thereof. This term, United States, in the 14th Amendment does not mean federal territory at all. It only means the states of the Union. So if you were born in the state of the Union and not, what did someone say? Oh, the state of the Union means the government or something, the government jurisdiction. That's inherently untrue, right? Like the way they try to encompass the United States to mean federal territory, they're meaning that the state is going to be, or whatever, the territory of the government of the state. Second, those who are naturalized in the United States and subject to the jurisdiction thereof. That's naturalization. In order to belong to the first class, two things must occur. The person must have been born within the United States and subject to the jurisdiction thereof. This jurisdiction must, at the time of both actual and must be both actual and exclusive. The words mentioned except from citizenship born, The words mention except from citizenship children born from United States in the United States of persons engaged in the diplomatic service of foreign governments. So this is diplomats, this portion. Such as ministers and ambassadors who reside by a fiction of public law as is regarded as part of their own country. This extraterritorially of their residence secures to their children born here all the rights and privileges which would inure to them had they been born in the country of their parents. Persons born on a public vessel of a foreign country whilst within the waters of the United States and consequently within the territorial jurisdiction are also excluded. And the reason why is this. Does not show intent of that foreign person wanting to become a citizen. He is doing a job for his country unless he renounces that in some way. They are considered to be born within the country to which the vessel belongs. In the sense of public law, they are not born within the jurisdiction of the United States, meaning they are not born within one of the states of the Union. So if a stranger, meaning a person who's passing through, so if a stranger or traveler passing through the country or temporarily residing here, but who has not himself been naturalized and who claims to owe no allegiance to our government, meaning no intention, has a child born here who goes out of the country with his father, such child is not a citizen of the United States because he was not subject to his jurisdiction. And the only thing that I could think of is because the parent had no intention to stay. He was, what do you call it? A transient, right? A person just passing through. And he's not a diplomat. It doesn't necessarily apply to just diplomats. But did this principle change? I do not know, because they have other court cases that show this, right? But as a principle at this time, this did not apply. The whole concept is that your intention to be domiciled here, right, prior to the birth of your kid is of utmost importance. But the children born within the United States of permanently resident aliens, all right, so that's the court case right here that I was thinking of, the Chinese one. The Kim Wang Ark case, that's the case. The parents were permanent residents. That means they were choosing to reside here. But permanently. They weren't just passing through to stay for a time. In Kim Wang Ark, the parents never gave up their allegiance to China, but they were choosing to live here as residents permanently. So of permanently resident aliens who are not diplomatic agents or otherwise within the accepted classes of citizens. And this is true even where the parents belong to a race of persons such as the Chinese who cannot acquire citizenship for themselves or naturalization. So the law banning them from becoming citizens did not ban them from residing within the country. So by choosing residency, right, becoming permanent residents to be afforded the privilege to live in one of the states of the Union, their children became citizens. They weren't, the parents weren't, but the children were. Because the Constitution, the 14th Amendment, flat out says all persons born within any state of the Union. There's no, mistaking that right there. Children of American parents born abroad are also considered as within the privilege of citizenship if the residence of their parents abroad was only temporary. So that's also key too. I want to read this right here. This is the Kim Wang. So this is annotation to what I just read. It says in Lu Ting Sing, so it's another Chinese case, and Wong Kim Ark, right? In the case last cited, it was said, at the common law, if the parent be under the actual obedience of the king, and the place of the child's birth be within the king's obedience, as well as in the dominion, so two things, the child becomes a subject of the realm. In other words, birth within the realm was deemed conclusive. This was decided in Calvin's case, reported by Lord Coke, and has always been recognized as the common law doctrine. And then they give you other citations on where that principle came from. By the law of nations, birth follows the political status of the father and of the mother when the child is illegitimate. Why do you think they want everybody to be no more married couples? They want to have broken homes. They want to have children born out of wedlock and so forth. Why? What does that make them? That makes them fall under their aspect. The 14th Amendment to the Constitution of the United States must be controlling upon the question presented for decision in this matter, irrespective of what the common law or international doctrine is. But interpretation thereof is undoubtedly confused and complicated by the existence of these two doctrines. In view of the ambiguous and uncertain meaning of the qualifying phrase, subject to the jurisdiction thereof, which renders it a debatable question as to which rule the provision was intended to declare. However, whatever of doubt there may be is with respect to the interpretation of that phrase. Does it mean subject to the laws of the United States, comprehending in this expression the allegiance that aliens owe in a foreign country to obey its laws, or does it signify to be subject to the political jurisdiction of the United States in the sense that is contended for on part of the government? This question was ably and thoroughly considered in Luke Tin Singh Supra, right, which I have not read that case, which I will be, where it has been held that it meant subject to the laws of the United States. And readers' attention is further directed in the case of Lynch versus Clark, where the common law rule of citizenship by birth within the jurisdiction is stated, recognized and declared to be the laws of the United States. So those are two cases that I'm going to want to read right here, if they come up, of course. Let's see what comes up. American. That's going to be, they don't give me the whole case. So VLEX, they don't ever give you, they want you to subscribe something. It'll be here. But I have to, so this one right here. All right, so that's one. And then the other one is Lupton Singh. Hold this over here. And I'll read that case. So there you go. Handful of cases that I'll be reading. It's important to have that understanding, in my opinion. All right, to continue. This is not the annotations no more. That was only annotation that I wanted to read, number 9. An act of Congress passed before the 14th Amendment, but probably not repealed by it, provides that persons born out of the limits of the jurisdiction of the United States whose fathers are, at the time of such birth, citizens of the United States shall be deemed and considered citizens of the United States. Now, you guys should know the 14th Amendment don't apply to that. The 14th Amendment is only birth here and naturalization. These are other principles Meaning if you are residing somewhere else and you're a U.S. citizen and you have a kid, well, through bloodline, like the Romans, you are also a citizen of the United States. Provided, however, that the rights of citizenship shall not descend to persons whose fathers never resided in the United States. This statute is in affirmance of the common law. By the common law, when a subject is traveling or sojourning abroad, either on the public business or on a lawful occasion of his own, with the express or implied license and sanction of the sovereign, and with the intention of returning, as he continues under the protection of the sovereign power, so he retains the privileges and continues under the obligations of allegiance. And his children, though born in a foreign country, are not born under the foreign allegiance and are an exception to the rule which makes the place of the birth the test of citizenship, like the 14th Amendment does. Now, what they don't include here is what the country also construes as citizenship. At that birth in a foreign country, you might have been one of their citizens also. You might become one of them, a dual citizenship there. The infant children of aliens, though born out of the United States, if dwelling within the United States at the time of naturalization of their parents, become citizens by such naturalization. They got a section on women and children, corporations, Indians. I'm not going to read those. I'm not going to read naturalization because that's a given. They got expatriatism, right? Expatriation, which is a right that everyone has to do. I'm going to read this part right here. Double citizenship in the United States, Section 230. We have in our political system a government of the United States and a government of each and the several states. Each of these governments is distinct from the other, and each has citizens of its own who owe its allegiance and whose rights within its jurisdiction, it must protect. The same person may be at the same time a citizen of the United States and a citizen of a state, but his rights of citizenship under one of these governments will be different from those which belong to him under the other. The distinction between citizenship of the United States and citizenship of the state is clearly recognized and established by the 14th Amendment. Not only may a man be a citizen of the United States without being a citizen of a state, which is true. You could be a citizen and be somewhere else. But an important element is necessary to convert the former into the latter. So that's what? Convert the former, the United States citizenship into a state citizen. He must reside within a state to make him a citizen of it. But it is only necessary that he should be born or naturalized in the United States to be a citizen of the Union. Think about what they just said right here. It is quite clear then that there is a citizenship of the United States and a citizenship of the state, which are distinct from each other and which depend upon different characteristics or circumstances in the individual. This statement is important because these are things that you possess. It is not you specifically. These are things that you possess, and this should be slaughterhouse. Yep, right here. That should be slaughterhouse. But all these court cases are good. You have the U.S. versus Krushenek. Right? Those are good cases right there. A person, therefore, may be a citizen of the United States without being a citizen of the particular state. And this is the condition of citizens permanently resident in the District of Columbia and in the territories. What did they just say? Now, the Bill of Rights apply to the District of Columbia. Why? Because the Bill of Rights are part of the law of the land, right? The land, right, was here first, right? And the law and the principles of thereof were there first before the District of Columbia was created. That means it attached to the land first and not to the local law of the District of Columbia. Since the power of naturalization is exclusively vested in Congress, the states cannot convert aliens into citizens of the United States. Whether the state can clothe an alien with the privileges of its own citizenship in advance of his naturalization by federal law is uncertain, which, if you guys are paying attention today, is literally what these states are trying to do. The illegal immigration that's happening today, states like Illinois, New York, and California, and I think Maine, right, are trying to give these people rights to vote, and they are not citizens, in blatant violation of the Constitution and the powers of Congress. Now, can Congress give these powers? I do not know. If they can, it would have to be, it cannot violate the Constitution. That would be considered, if any of you study trust law, an administrative power, not a ministerial one. If it were to violate the Constitution. If it doesn't violate the Constitution, then it's the other way around. It's a ministerial power and not an administrative one. There is nothing to prevent the state from giving him the right of suffrage, the right to vote, the right to inherit and transmit property, and all other rights generally deemed to be appertinent to citizenship, except the right to be subject to the federal jurisdiction and to claim the benefit of federal law as a citizen of the United States. But this right here, when they talk about aliens, though, they're talking about legal aliens, lawful to be here, not illegal. You can't have no rights if you're illegal and breaking laws. In terms of this class, class of persons in citizenship. On the other hand, the United States can naturalize a foreigner, but cannot make a citizen of any particular state. So they can naturalize them in accordance with with congressional laws. That depends upon his own choice. He becomes a citizen of that state in which he shall reside, but the state cannot withhold the privileges of its citizenship from any person born or naturalized in the United States and subject to the jurisdiction thereof, who shall choose to dwell within its domain. The most that a state can require is a bona fide intention to become one of its residents. And perhaps it is within the competence of a state to fix the term of residence within its limits before the rights of citizenship shall attach. I don't think I'm going to read the privileges. I'm not going to read the privileges because those are, the stuff you get. These are of the assuming the national character, right? The 14th Amendment also declares that no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, right? So this is specifically the 14th Amendment, privileges and immunities. So I'm not going to read these. And that'll be the end of that book right there. So the next book, this should be the 1911 book. So same thing, political and public rights. How long is this one? Because I did not want to go over an hour. All right. The 14, a lot of this is going to be repetitive, but my purpose to do this is that you're talking about a huge time frame between these books and different authors that are stating similar things, right? And there's certain modern day books that reference the same concept and in the same context, right? And in a recent video that someone on Telegram posted in a open mic, right? He read a manual from the military from 1927, I believe. And he was correct in his assessment that these are rights that we possess, more so than us being those persons, right? These are rights that we possess. We choose if and when we benefit from them. If you're not using them, then you can't be held liable to certain things. It's a distinction that has to be understood, and it can only be understood through context. Because there is no doubt that you are a U.S. citizen, as much as butthurt you're about to be for that statement. You are a U.S. citizen. The term U.S. citizen encompasses both federal and state. I don't know how else to put that. In the passport, that's what it means. For the passport application, that's what it means, right? That is going to be what? Title 22, right? Code of Federal Regulations, what, 51.1? The definition for United States is the American Empire. The definition for citizen is all inclusive. You can't make that shit up. The 14th Amendment to the Federal Constitution declares all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and the state where they reside. So, with respect to the manner of acquiring citizenship, the citizens of the United States are divided into two classes: native-born citizens, naturalized citizens. These are the bullet points of what I'm about to read. Citizenship in the United States is not restricted to adults and males, but belongs equally to women and children. Corporations cannot be citizens of the United States, and Native Indians, though born within the United States, can become citizens only by naturalization. The right of expatriation is fully recognized in this country. Now, I'm not going to read this whole thing because it's a repetition of the other one that I just read, especially with the Dred Scott case and so forth. I just want to show, at least in this last book, that they're stating the same thing. I'm going to read this part though. I think it's important, especially the annotations in this portion. Citizenship is the status or character of being a citizen. And a citizen of a given state or country is one who owes its allegiance and is entitled to its protection. The two correlative ideas of allegiance and protection from the basis of the legal and political conception of this citizenship. The citizenship is subject to the jurisdiction of his country and to its laws. It owes it loyalty, his services and needs. So this is the same author. These two I think are the same author. This is going to be the second edition, right? So I'm going to skip this part. I want to read this because this wasn't in the other one. So this is allegiance. Allegiance is the obedience due to the sovereign. The persons born in the allegiance of the king are his natural subjects and no aliens. The allegiance is not limited to any spot and is due to the king in his natural capacity rather than his political capacity. As the Constitution nowhere defines the meaning of the word citizen of the United States, except by the declaration that on the subject in the 14th Amendment, resort must be had at the common law, the principles of which were familiar to the framers of the Constitution. And that's what I have said continuously. The 14th Amendment, right, is a principle of common law that they made an act out of and recognized it as a whole for the country. The character or attribute of having citizens can belong only to a sovereign state or nation. Legally, there is no such thing as being a citizen of a country or any other municipality. Let's repeat. Let's read that right there. Legally, there is no such thing as being a citizen of a country or any other municipality. I wonder what he's saying there. Because this is the character or attribute of having citizens can belong only to a sovereign state or nation. And in this case, this semicolon represents the word and without using it. So these go together. Crap. These go together, those two sentences. Legally, there is no such thing as being a citizen of a country. I do not know what he means by that. The only thing I could think of is it's because in this case, they're talking about your allegiance applies to the government and not the country itself, like the land or some city. That's the only thing I could think of. They give you a case here, which might as well look it up. Come on, why are you copying all that? And I will look it up because that's what I do. Oh, I gave it to him. I didn't copy everything. Can't use that one. So it's not here. I'll have to go to law library or somewhere else because this ain't the case here. At least unless it's down here somewhere, but you would think it would give it one of the first aspects of it. I have to look that up at the law library when I get a chance. The mode and manner of ascertaining the fact of citizenship is for Congress to determine, and it may vest the power to determine such fact exclusively in executive officers. And then they give you another case. I don't know what this is. December Digest. I don't know. I don't know what DEC stands for. Native-born citizens are the same. I'm looking for the annotations in this PDF more than reading the PDF itself. And like here's Elk versus Wilkins. A citizen of the United States who becomes a member of an Indian tribe by adoption does not lose his citizenship. So if you somehow become a member of some tribe, you don't lose your U.S. citizenship because you were a citizen first. Unless you choose to, like you have to expatriate. That's different. Just by becoming a member of an Indian tribe does not automatically lose your citizenship. Your intention has to be included in that. Double scissor, that's the same stuff that we read a little bit ago. All right, so that's the same. So this is the 1915 one, the last PDF. Section 591, Fundamental Constitutional Rights. Perhaps the most important branch of constitutional law is that dealing with the fundamental rights. The framers of our Constitution thought that there were some individual rights, such as those of life, liberty, and property, with which the government should not arbitrarily interfere. Consequently, they wrote them into our Constitution, and they cannot now be altered or impaired except by constitutional amendment. The purpose of this chapter is to briefly review these fundamental rights and determine their scope and meaning. Section 592, Citizenship and Naturalization. Citizenship is membership in a political community or group. In this country, there are two kinds of citizenship and allegiance, one national and the other one state. It is for Congress to determine who shall enjoy the privileges of national citizenship within the limits prescribed by the Constitution, and the laws of the several states fix the conditions under which state citizenship is acquired. No state can make or enforce a law which shall abridge the privileges and immunities of the citizens of the United States, which is federal citizenship. This is a provision of the Constitution of the United States, and any state law to the contrary is void. It is further provided in the Constitution that the citizens of each state shall be entitled to all the privileges and immunities of the citizens of the several states. So that's a state right? State privilege. The right of a citizen to expatriate himself and to become subject to another nation was a question in this country until Congress passed a law recognizing such rights. So why do they say it like that, right? Where it says, it is further provided in the Constitution that the citizens of each state shall be entitled to all privileges and immunities of citizens of the several states. That's because even a person who becomes naturalized, right? He, by residing in that state, he becomes a citizen of that state, no different than a person that was born there. That means that what? He is entitled to all the state citizenship rights and privileges and immunities. And what do we call them? Fundamental rights, protected by the Constitution. Citizenship is acquired by birth or naturalization. The 14th Amendment provides that all persons born naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. Congress has also provided by law that all persons born outside of the limits of the United States whose fathers are at the time citizens thereof shall be deemed citizens, which is, of course, we already read in these other ones. The power over naturalization is vested in Congress. It is within the power of the states to adopt citizens on easier terms, blah, blah, blah. And then it goes into suffrage. It's all the rights. Freedom of speech, right to bear arms, liberty, right, religious liberty, protection to persons accused. Now here's the real catch. How they state the U.S. citizen, how you're entitled to all the privileges and immunities of citizens of the several states. A U.S. citizen from the District of Columbia does not get all of them. They only get specific ones that were attached to the land. And same thing, but that's only to them. Now you're talking about citizens of the United States that are living on other territories that are not part of the country, like the District of Columbia is, a part of the land, like the District of Columbia is, right? Like Puerto Rico and everything else. Those are different. They're United States citizens without state citizenship. It's a huge distinction. Their local law is the territorial law of Puerto Rico. If they do, which they do, Puerto Rico, right? The U.S. citizens there, they do have protected fundamental rights, but it's not because of their birth. They have them because they were given the privilege by statute from Congress that the Bill of Rights applies to them. If they were given to them by statute, that means they could take it away also. There's the difference in terms of U.S. citizenship here, specifically in the State of the Union, and U.S. citizenship like Puerto Rico or Guam or anywhere else. So that's going to be all. I'm going to read this though right here. Section 603, laws impairing the obligation of contracts. The federal Constitution provides that no state shall pass any law impairing the obligation of contracts. There is no such express provision applying to the federal government, but it has been held that contracts are property, and therefore the government is prevented from interfering with them by the Fifth Amendment, which forbids the taking of property without due process. Grants, corporation charters, and ordinary agreements have been held to be contracts within the meaning of this provision. An impairment of the obligation of a contract is anything which prevents one of the parties from performing or which materially impairs the remedies for the breach of a contract. Thus, it has been held that a state law postponing or impeding a collection of debts by creditors is unconstitutional and void. A statute of frauds embracing a pre-existing contract not before required to be in writing is void as in conflict with this provision. A state law repudiating its bond issue or refusing to accept bonds in payment for taxes as was previously provided is unconstitutional on the same grounds. Let's repeat that again. A state law repudiating its bond, so its bond, meaning of the government, right? Issue or refusing to accept bonds, I don't know who from, right? In payment for taxes, which you would think it's from individuals or corporations, right? Or states and whatever else. As was previously provided is unconstitutional on the same grounds. In the historic Dartmouth College case, it was held that a statute changing the terms of the charter was an impairment of contract obligations and void. It was held, however, that all contracts are made subject to the state's power of regulation in the interest of public welfare. Thus, it has been held that a charter issued to a corporation to carry on lottery business may be repealed by subsequent statute forbidding the lottery business altogether. Where two private parties contract to go into a liquor business, a subsequent law prohibiting the liquor business is valid, although it makes impossible the performance of the contract. So hopefully you guys enjoyed that and understood what I was saying. If you guys have any questions, of course, you guys always could message me or send me a message on Telegram or whatever else. I will be posting this video both in the elementary law topic and in the citizenship topic also, since it pertains specifically to citizenship. So not all elementary law videos that I will be making will go into citizenship and all that. It will all go into elementary topic. So with that, thank you for participating and watching, if you were able to withstand it all. Hopefully you guys like and subscribe on my Butterfly Monkey channel. And thank you for listening. Have a good one. Till next time.